Well, right when you think that all of the excitement in the Karen Reed case is going to subside and we'll be able to start directing our attention to some other cases, well, then we get a motion to dismiss filed by Alan Jackson and David Yannetti to completely dismiss count one and count three. Now, even though there's already a hung jury and there's a mistrial declared, they want that count one and count three be completely dismissed. And therefore, even if the Commonwealth wants to retry Karen Reed, they should be limited to count number two. Count one, of course, was the most serious, second-degree murder. Count three was leaving the scene. Count two was the involuntary manslaughter because of the intoxication. So still a serious charge, but not second-degree murder. So that's what they're asking for in this motion. Now, I will say that do want to tell everyone that as soon as I heard about this coming out of the news, as soon as I just heard about it, and I was hearing different reports about it, and I actually got the motion and I read it. Let me tell you, there's some misconceptions out there, and I think people are well-meaning, but they're just misunderstanding certain things. And that's why here I am to kind of explain this, break this down, and give you the appropriate analysis, the correct understanding of really what's going on in this motion and whether any of this has any merit at all. Now, I will say that as soon as I heard about this the first time, as soon as I heard that they're going to be filing this motion to dismiss because they spoke to some jurors after the jury deliberations and some jurors are telling them different things. The first reaction that I have, as would any trial lawyer, the first reaction would be that this is going nowhere in a hurry. Okay, because once the jury leaves the jury deliberations, it doesn't matter what they tell the attorneys. You're not going to reopen the case. You're not going to be able to change the verdict. It's just not happening. It's been tried time and time and time again. It's just not happening. The only time that really you can get anywhere with reopening a case or having an evidentiary hearing is like what we found in the Alex Murdaugh case, where you had jury tampering going on with the court clerk. So then if it's absent something serious like that, you're not going to be able to get the jurors back and have an evidentiary hearing and talk to each juror and see what their vote was, especially once they leave the jury. It's just not happening. That's the knee-jerk reaction. That's the natural reaction of any trial lawyer who followed this or heard about this. That would be the natural reaction. But I will say that I read some parts of this motion, and I think that there is an interesting, novel argument here, which does have some merit. Now, even though it does have some merit, I believe, still, to get a judge to call the jurors back and grant this type of relief is very, very unlikely. So therefore, what I'm saying is that even though I think that there's one part of this motion which may have some merit, and by the way, it's not the part that most people are talking about, okay? Because they just don't understand. But the part that actually does have merit in my mind is still to get the judge to completely change all this and to grant the relief here is very, very unlikely. Okay, so I said that very clearly from the outset, but still, I'm going to analyze this under the law like I always do. All right, so let's go through some of the motion together. I'm not going to obviously read the entire motion. I'm going to go through some parts of the motion, and then I'm going to play for you also a clip, which I think is very interesting, and there's certainly something to talk about with this clip, and this is really a big basis for their motion. So we're going to play that clip also as we get later on into the motion after we analyze some of this. So here is how the motion starts out. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges. So the jury actually reached a unanimous decision to acquit her of counts 1 and 3. And alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. Well, there you have it in the first paragraph, bringing out double jeopardy. Trying a person for the same crime twice. After they've already been acquitted, you're trying them again. That is basic double jeopardy, and you're violating that person's constitutional rights to not be tried twice for the same crime. So again, what's going on here? Just in the first paragraph, what we see is they're asking for, number one, that she should be acquitted. Just completely, just change the verdict now, change the verdict form, change the verdict to acquitted on count 1 and count 3. Alternatively, because there was no, and this is the magical words, manifest necessity supporting the declaration of a mistrial, meaning there was no necessity, there's no manifest necessity for the judge to declare a mistrial. Therefore, she should not be charged on those charges again. So really, if you think about it, and I think they should have made this more clear in their papers, if you think about it, really, under the alternative theory, which I think happens to be a stronger theory than the first theory, under the alternative theory, really, they should not be allowed to bring this case at all. All counts should be dismissed because this mistrial should have never been ordered. So that's what I think, and I think they should have made that a little bit clearer, but that is essentially what they're asking for. Now, let's continue. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications. Now, why does he say unsolicited communications? Why are you not allowed to reach out yourself and talk to the jurors? Well, it could be just letting the judge know that, hey, I didn't do anything funny over here. I didn't reach out to anybody. That could be one reason. Or it could be the judge says, I don't want you talking to them. So, and with respect to that. But either way, this is Yannetti who signed the paper. So he's saying that we began receiving unsolicited communication from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. So we spoke to 3 jurors who were all deliberating. These weren't like alternates. They were actually deliberating jurors. And the 3 told us that the voting was 12-0 when it comes to second-degree murder. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, so maybe the court feels, well, this is just 3 out of 12. Maybe, who knows what the other 9 are saying. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry, otherwise known as an evidentiary hearing, to be held on the issue that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. Okay, so that is all in the introduction part of their motion to dismiss. So we've got these jurors. These jurors say the voting was 12-0. You want to have further factual development? Let's call them in. Let's call all the jurors in. Let's see if this is a consensus. Did they all unanimously agree that it was 12-0 on the second-degree murder? Sounds like a reasonable, request. All right, and then they get into more. On July 1st. So now, you know what? I'm going to play this right now for you, and I'm going to point out something which I thought stuck out to me as someone who's tried cases, and it certainly stuck out to some other attorneys that I've spoken about this, who are trial attorneys as well. And this is what they talk about in their motion. So let me play this for you without any further ado. This is when the mistrial is about to be declared. I put it on 1.5 just to go a little bit faster, and we can see what happens.
Thank you. Be seated. Closing session.
22117 Carwell versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
Okay, so let's notice what she said here. The jury is at an impasse. Let's bring the jury in. Okay, so how does she know that the jury's at an impasse? Well, she must have gotten a note from the jury, right? So she got a note from the jury saying that the jury's at an impasse, that something that the note said that indicated to her that the jury's at an impasse. So now right away she says, let's call the jury in. Now let's see what happens.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so court, please.
Now that's it. So that's it. So she reads the letter. She tells, after reading the note, she says, okay, I'm declaring a mistrial. Go to the jury room. I'll be in to see you shortly. Now, the reason why that stuck out to me and most other trial attorneys is for the following reason. When you get a note, when the judge gets a note by the jury, usually the same thing happens, okay? The attorneys are called into the courtroom. The judge says, I received a note from the jury. Now, the jury's not there yet. You get a note from the jury. They let the attorneys know. The attorneys come. The judge says, I got a note from the jury. Let me read it in open court. She reads it, or he reads it. The judge reads it. And then she has some questions. Okay, what do you think we should do? Let each side make a record about what they think that should happen because of that note. Usually it's a simple question, but sometimes, there's room for some argument about what the judge should do in that situation. After there's argument, the judge will say, okay, I'm going to do this specific thing. All right, bring the jury in. They bring the jury in. She reads the note again, and then she says, and this is what I'm going to answer to that note. She gives the answer, and then she excuses the jury. The reason why this was peculiar in this case is that she did not do that. She didn't read the note before the jury got into the room. Before the jury got into the courtroom, she didn't say, okay, I received the note. Let me read this note in open court in front of both attorneys. Attorneys, do you have anything to say about this note? What do you think I should do? Do you think I should declare a mistrial? What do you think, Mr. Ionetti and Mr. Jackson? What do you think, Mr. Lally? Let's talk about it. And actually, you did see that in the other notes that she received. So she did do that in before. But all of a sudden, this last note, where she already made up her mind, okay, I guess if they send another note, this is after the Tui Rodriguez instruction. If they send another note that they're deadlocked, I'm just going to declare a mistrial. But she didn't follow this normal procedure, which is that you read the note first to the attorneys and ask them, what do you think that they should do? Now, most likely, if she would have done that, then Mr. Jackson or Mr. Ionetti would have said, Your Honor, I think we should move for a mistrial. I think you should declare a mistrial. Most likely, that's what they would have done. But they didn't do that because she didn't give them the opportunity to do that. And that's going to really be a big focus of their motion. The fact that they didn't get the opportunity to talk and say anything about what possible avenues the judge can do and not declare a mistrial. She just read the note, declared a mistrial, sent the jury away. All right. So this is how the motion reads. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. That's all the judge said, right, as we just heard. Once the jury was seated, the court then read the jury note verbatim in open court. That's what she did. And without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. That's exactly what just happened. In short, neither defense counsel nor the defendant consented to the mistrial. So they're arguing, we didn't consent to the mistrial. Meaning we didn't want them to have a mistrial. Maybe the defense, up until now, obviously the defense was trying to get them to be hung and just have a mistrial declared. And Mr. Lally was always saying, no, they need more time, they need more time, they need more time. Now the defense is going to make the case, no, we wanted them to have more time. And the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictments. Meaning, if you would have given us the opportunity, would have said, well, Judge, maybe you should ask the jury which part of the charges they're deadlocked on. Are they deadlocked on all of the charges, or maybe just one of the charges, or count one, count two, count three? Maybe there should have been an inquiry into what they're deadlocked. You didn't give them the opportunity. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that they're keeping them anonymous, wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count one, second-degree murder. Juror A was emphatic that count one, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count three, leaving the scene with injury/death. So this is Alan Jackson, who's being approached by a juror, saying that count 1 and count 3, we were completely in agreement that 12-0, that she should be acquitted. Another day later, on July 3rd, 2024, Attorney Yannetti, so now not just Jackson, but now Yannetti is being contacted by 2 different individuals. Now, these 2 individuals were not actual jurors. They're what they're referring to as informant B and informant C, who had received information from 2 distinct jurors. Now, Yannetti's getting this information from informant B and informant C. So informant B and informant C are telling Yannetti what the jurors told them. So like double hearsay, right? All right. Hereinafter, juror B and juror C, both of whom were part of the deliberating jury in this case. Informant B sent Attorney Yannetti a screenshot that he/she had received from someone of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. So they were split on the second charge. And then this is continuing the text message. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had been in contact with another individual, intermediary C, who is a coworker and friend of juror C. So now we have 3 different levels of hearsay here. And joined a Zoom meeting during which juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what juror C revealed in Zoom meetings. So now we have 3 different levels. He said, she said that this is what the juror said. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlocked at 4 no, 8 yes. So for the second degree involuntary manslaughter was 4 we're going to vote no, and 8 we're going to vote yes, that she is guilty, presumably. All right. So that is the second part of their motion. Now let's continue. So their first argument, and this is, I think, what everyone's getting excited about, is that the jurors have all now voted, and they've all, they only spoke to 3, but the 3 jurors, either directly or through intermediaries, through informants, they've said that, again, count 1 and count 3 should be dismissed because they all agreed 12-0 that she should be acquitted of those counts. Okay. Now, they attached affidavits by Attorney Alan Jackson and Attorney Yannetti. So there's no affidavits yet of the jurors saying this. Okay. So that's number 1. These are just affidavits from attorneys. Now, some people will say, well, affidavit, I mean, this is all hearsay. It's Attorney Jackson saying what a juror told him. That's one hearsay. And then you have Yannetti saying what an informant told him, what an intermediary told him, what a juror said. Well, that's like so many different levels of hearsay that, I mean, this is just ridiculous, right? And these aren't even affidavits filed by the jurors themselves. So now that's a decent argument. However, in motion practice, you are allowed to submit affidavits, right? That's the whole point of motions. You don't have to follow all the rules of evidence when you're filing motions. It's the idea is to get the issue in front of the court, to show the issue that this is an issue worthwhile going into and thinking about, and if necessary, have an evidentiary hearing about it. And the affidavits are there just to show that people are willing to swear under oath that these things happen, and therefore the court should take further action, but not that they have to follow the rules of evidence. So therefore, when people say, oh, this is all hearsay, yeah, it is hearsay. All affidavits are hearsay. In fact, all affidavits are hearsay. Okay, so the point of all these affidavits when you have a motion is just really to show the judge that this is a serious issue. People are willing to swear to it, and therefore, if necessary, we are asking for an evidentiary hearing where we can have people go under oath. Now, will this part of their argument win? And this is what I can be pretty confident to tell you: no. Okay. 99% of the times, just because jurors are talking about afterwards about what the voting was, who knows? Everyone could be making stuff up, and we're not going to start creating a precedent where when jurors start talking after the deliberations, you're going to go bring everybody back. They just sat through 30 days of trial and deliberations, and I'm going to bring everybody back because a few jurors were upset. Maybe they were upset that their conviction of Karen Reed being not guilty was not upheld, and therefore they're going to bring everybody back and force everyone. I mean, that's ridiculous. It's just not going to happen. So that part of the motion, I feel, is the weakest part. Okay? But here, let's move on to the next part of the motion. The next part of the motion, I think, is a little more novel, a little bit more interesting, and where I think they have some merit. And that goes back to the video, the clip that we played for you, how the judge found and ordered a mistrial in this case. She did not allow any sort of argument by either side with respect to the notes and what she should do. So let's continue with this. Thus, where a mistrial is entered, okay, let's start from the beginning. The double jeopardy, this is section B of their motion. Again, I'm skipping around just because I want to get you to the main parts. This is section B. The double jeopardy, this is a straight out a quote from a case, Taylor. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Meaning, if you have a specific jury and you're the defendant and you want this jury to make the decision, you have a right to have that your trial be heard by this specific jury, and not just, you know what, I'm not in the mood of trying this case this week. The judge can say, you know, I'm not in the mood. Let's just excuse the jury. We'll pick a new jury next week. We'll give everybody the preemptory challenges and all the regular challenges. We'll give even more preemptory challenges. No, you're not allowed to do that. Once the jury is being seated, then and the defendant likes this jury, then they have a right to keep this jury. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible. Full stop. When a mistrial is entered without the defendant's request, was there a request for a mistrial? No. If she would have said, before she called the jury in, Mr. Yannetti, Mr. Jackson, what would you like the court to do in this situation? I almost can guarantee you that they would have said, we think you should declare a mistrial. Okay, that's a request. Now you requested it. Now you can't argue anything that you're arguing in this case. But she didn't do that. So now they didn't request it. But the second question is, was it with their consent? Now we know that when you're a lawyer and you're sitting at counsel table and something goes on in court that you don't agree with, what should you do? Should you stay there quietly and say, well, okay, I can always appeal? No, you object, right? You say, Your Honor, I object. I'd like to make a record. Now they didn't do that here. So now you can be asking yourself, you can be wondering, is this considered consent or not? Did the defense consent to this mistrial being ordered by the judge? If you can find that there's no request, which there clearly wasn't, or there's no consent, then retrial is impermissible. And we'll get to the second prong of this in a second. But the first question you can ask is whether this is considered consent or not. And here they bring a case, they cite a case, which is Commonwealth versus Edwards, which rejected the argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. So in Commonwealth versus Edwards, a very similar situation happened, where the defense did not object, and the Court of Appeals had to decide, well, is that considered that they consented to the mistrial? If they consented to the mistrial, this whole motion is out the window. So did they consent or not? And this is where they're saying the fact that Jackson or Yannetti did not object does not automatically mean that they consented. All right, so that's what they're quoting from Commonwealth versus Edwards. All right, so now let's get past that prompt. Let's get past the. Let's assume, just for argument's sake, that they did not request. That's clear, and that they did not consent, which means that generally speaking, the mistrial would be a retrial would be impermissible. However, the case continues, and this is going back to Taylor. So listen to what the case says. The case says, unless, okay, so you're not allowed to try the case without the defendant's request or consent for mistrial, unless there was a manifest necessity for the mistrial. Okay, and that's why I stressed in their introduction when they talked about manifest necessity. Well, what does that mean? Meaning, if there was manifest necessity for the mistrial, then the judge, they could be retried on this case. They could be retried for these same crimes. There would not be any problem of double jeopardy. Well, I had to pull a certain case because the defense did not want to pull this case. They didn't want to pull this quote for very obvious reasons, as I'm going to see soon. But I had to actually pull this because if I was, I'm curious about this. I'm doing a little bit of research myself before I put out these videos. So I wanted to see about this specific question. Well, what would be if the jury can't agree on something? Isn't that a manifest necessity? What are you going to have the jury deliberate for all time, for the rest of all time until they come to a verdict? Isn't that manifest necessity that these people have been deliberating for 28 hours and they want to go home to their families and they want to go back to their jobs? Isn't that manifest necessity? Well, if you're thinking that, then you're not far off, because that's exactly what the cases say. A frequent and traditional example of manifest necessity is where the jury were discharged because they were unable to come to an agreement on a verdict. That's exactly what it is. This is quoting Thames versus Commonwealth. The trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. So exactly what you're all thinking, and exactly what I was thinking, that if there's a jury is hung and they can't come to a conclusion, well, that itself is manifest necessity, which would mean that even if the defendant did not request a mistrial, and even if the defendant did not consent to a mistrial, but if there's manifest necessity for the judge to order a mistrial, well, too bad. They get to retry the case. The Commonwealth gets to retry the case if they want. However, it's not that simple. Why not? Why is it not that simple? Well, you have to continue because there's some other case law that tells you about what has to happen if there's manifest necessity. And this is where the courts say the following. Before a court declares a mistrial for manifest necessity, before. So you want to use this example, you want to use this exception of manifest necessity? Well, this is what has to happen before. Number one, counsel must have been given full opportunity to be heard. And two, the trial judge must have given careful consideration to alternatives to a mistrial. Two very important caveats that you have to follow if you're the judge and you want to use manifest necessity to issue a mistrial is that counsel must have been given a full opportunity to be heard. Well, I just played you the clip. Was the defense given any sort of opportunity to be heard at all? Now, we know what they would have said, right? They would have said, sure, you should declare a mistrial. Of course they would have said that. But they didn't because she didn't give them the opportunity to. So now is that going to come back to haunt the Commonwealth in this case? Because counsel was not given a full opportunity to be heard. And this is what they argue. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. So even forget about prong number two. Forget about any alternatives to a mistrial. The fact that you did not give counsel opportunity to be heard. So you may say, well, what do you want the judge to do? What do you think would have happened if they would have, let's say the judge would have given you the opportunity to be heard. What would you have said? Keep the jury here for the next 8 months? It doesn't matter. That's what their argument is. The first prong is a requirement. You have to let the attorneys be heard. And if they're not heard, then that's it. You failed this prong. You cannot use manifest necessity. You cannot retry Karen Reed on any of these counts. That's their first argument. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel, which I pointed out to you. This was a peculiarity. This doesn't happen. It's peculiar. Now, let's move on to the second prong. They say, okay, this is, of course, what you have to do when you're briefing these type of issues. You can't just rely on that part. Say, okay, let's move on to the second prong just in case the judge, or the Commonwealth will find some sort of argument or some sort of case law that would say that counsel doesn't have to be given full opportunity to be heard. I don't know. So they go to the second prong. The record is independently lacking on the second prong, as it reflects to no careful consideration. What does it mean, careful consideration? I would argue. I would talk to you about, right? What does that mean? Careful consideration, I would think, means consideration on the record. Saying, okay, well, what do you think we can do in this case? Counselors, what do you think we should do? Do we have any sort of alternatives besides issuing a mistrial, besides ordering a mistrial in this case? Are there any other alternatives? Let's discuss it. Let's have a full record about what possible alternatives there are. So I would think that that's number one, a requirement of careful consideration. And number two is what are the alternatives? You didn't even discuss any of the alternatives. So the second prong is that as it reflects to know that there's no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative. So now the defense is saying, forget about even considering it and talking about it and carefully considering whether there is even one that exists, which they would argue by itself, the fact that you didn't do that violates the second prong. Even if there is no alternative, they would argue, which they didn't, but they should have, that the fact that you have to discuss that and consider it on the record is important and a requirement. But now they're going to create an alternative. And here we go. Here there was one obvious alternative, to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of juror A, B, and C, the double jeopardy implications would have been clear and decisive. So here we go. And now the question would be, okay, so now what do you want them to do? You want to tell the jury, well, there's 3 counts here, right? There's second degree murder, and then there's a lesser included, the involuntary manslaughter, and then they're leaving the scene. So so you're asking the judge, well, the alternative could have been that ask them which counts they are deadlocked on and which counts maybe they agree about. And then we can have a separate verdict for count 1 and count 3 would be not guilty, and count 2 would be a hung jury. Why don't you do that? And is there any case law that says that you can't split up the verdict like that? And they do bring a case that says that you can't always do that. The Supreme Judicial Court's holding in Commonwealth versus Roth, it said that the court should not request partial verdicts on lesser included offenses charged in a single count, but that's only if it's charged as a single count. That does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged. So only when you have lesser included that are not separately charged, then the Roth court would say not to do this, to split up and ask the jury, well, which counts? Let's split up the counts about which ones you're deadlocked on, and we'll continue the deliberations in that form or fashion. But here they're saying that was not the case in this case. With the Karen Reed case, no similar danger is present, whereas here, the jury was asked to return 3 separate verdicts on 3 separate counts. So here they're arguing, well, there's 3 separate counts, not just 3 charges all wrapped up in one count. There's 3 separate counts, and therefore the judge could have alternatively told the jury which counts are you deadlocked on, which ones aren't, and then they would have gotten the verdict of non-guilty on count 1 and count 3 and deadlocked, and then issue a mistrial just on count 2. So what I think, again, the novel part to me, the argument that has some merit in my understanding and in my analysis is this part, the fact that the judge did not give opportunity for the counsel to be heard. And I think that is more of a winning argument as opposed to, well, the jurors told us afterwards that they would have voted 12-0 to quit on count 1 and count 3, and therefore we should reopen this case and have an evidentiary hearing. No, I don't think that that's really where you win the case. I don't think the jurors have to do with anything in this case, with this motion. The way that I see this motion having any sort of merit is just by the way that the judge issued the mistrial. Forget about what any jurors had to say about after the deliberations. The fact that the judge did not allow any sort of argument, and therefore you can argue that the mistrial was not requested by the defense, and it was not with their consent, even though they didn't object, as we spoke about. And this cannot be considered manifest necessity to issue a mistrial because, number 1, you failed the prong of giving the counsel opportunity to be heard. And number 2 is that you didn't carefully consider alternative measures in this case. So that's why I think that this is interesting. Now, is this going to go anywhere? 99% of the cases, it doesn't go anywhere. But I still want to point out that I think that there's a very interesting and compelling argument here. And I think that there's some merit to this argument. I would be interested to see what the state, the Commonwealth, is going to respond to this motion. So my guess would be, just like in 99% of the other cases, this is not going to go anywhere fast. The judge is not going to do anything about it. And it's probably going to be either just saved for appeal if they need appeal at some point. But, I think that it's still interesting, and I think that there is some strong merit to some of their arguments. All right, well, that is it for now on the Karen Reed case. Always some more excitement with the Karen Reed case, and we will see what the Commonwealth responds to the arguments. It'll be interesting to see how this all plays out. Well, that's it for now. Please, if you haven't yet, subscribe, like, and of course, we will see you next time.